In preparation for the initial meeting with a lawyer to discuss your estate planning matters, you should compile specific information and make specific decisions, as outlined in this video. Ask your attorney for an estate planning worksheet to assist you in completing some of those tasks. In general, you should be prepared to supply the following personal data: your name, home address, and telephone number, business address and telephone number, position held, approximate annual income, birth date, and social security number. Your spouse's name, business address and telephone number, position held, approximate annual income, birth date, and social security number. Your children's names, addresses, and birth dates. The location and contents of any safe deposit box you or your spouse may have. Copies of existing wills, trusts, powers of attorney, prenuptial or postnuptial agreements, divorce or separation agreements or decrees, summaries of employment benefits, and insurance policies. Listing of assets and indication as to ownership of those assets, i.e. jointly owned, individually owned by husband or individually owned by wife, including bank accounts, certificates of deposit, credit union accounts, and cash, indicating approximate amount, location, and type of account. Bonds, stocks, or other securities, specifically noting any ownership in closely held businesses. Real estate, indicating location, approximate mortgage amount, and approximate market value. Insurance, indicating company, face amount, approximate amount of any outstanding policy loans, name of insured, name of owner, and named beneficiaries. Tangible personal property, such as household goods, jewelry, furs, artwork, antiques, or automobiles, indicating whether any of those items are to be disposed of in a particular manner or to particular persons. Any other property interest, such as sole proprietorships, partnerships, death benefits, retirement benefits, trust benefits, annuities, etc. You should be prepared to supply answers to the following questions. Who is your choice for the person or entity to administer your estate? Who is your alternate choice? Who is your choice for the person or entity to serve as trustee of any trust established as part of your estate plan? Who is your alternate choice? Who is your choice of guardian to have custody of any of your minor children should something happen to you and your spouse? Who is your alternate choice? How do you want your personal effects and household goods distributed after your death? If the property is to go to your spouse, what should be done in the event your spouse does not survive you? Are particular items to go to particular persons? How do you want the balance of your property, stocks, bonds, bank accounts, real estate, etc., distributed after your death? If the property is to go to your spouse, should the distribution be outright or in a trust? How should the property be distributed after your spouse's death, or if your spouse does not survive you? Is any of your property to be held for minor children or grandchildren after the deaths of you and your spouse? How do you want your property to be distributed if all of your primary beneficiaries die before you? Are there any charitable bequests that you want to make, either at your death or following the deaths of both you and your spouse? If so, what charities are to be named and what dollar amount or percentage of your estate is to be distributed to each of the named charities? Documents to bring to conference. Existing last wills or trust instruments. Divorce or separation agreements. Powers of attorney. Summary of retirement plan benefits. Pre- or post-nuptial agreements. And life insurance details.